Good evening, everyone, and good morning or good afternoon to our participants from different time zones. My name is Dov Salomon. I am a law professor at the College of Law and Business, and I will be the moderator of this panel. The title of the panel is Crowdsourced Labor and Crowdsourcing Labor Rights. We have two interesting papers and 45 minutes for each paper. First, the commentator will have 15 minutes to present the paper and comment on it. The author will then have 10 minutes to respond, and then the floor will be open for discussion with all participants. I will let the speakers know that the time is short by using the chat. Please mute your microphone if you are not asking questions, and use the raise hand options or the chat if you wish to ask questions or give comments. So the title of the first paper is Technological Advancements and the Right to Just and Favorable Conditions of Work, a Business and Human Rights Perspective. It is written by Izabela Schiffauer from WSB University of Wroclaw and Łukasz Szoszkiewicz from Adam Mickiewicz University. The commentator is Gali Racabi from Harvard University. So Gali, please.
Thank you so much for having me. I would like to start by thanking the organizers of the conference, Shelley Kritzer-Levy and Professor Tamar Megiddo, for such a kind of impressive and interesting subsectional, intersectional conference. And I would also like to thank the authors for providing me the opportunity to engage with a perspective I'm less versed in, one of international human rights, to a question I'm more versed of, the question of platform work and the classification struggles. So at the beginning of the article, the authors state two what they define as the most relevant questions with regard to platform and work. And the first question is, do technology firms, as they themselves purport, merely connect consumers and suppliers, or do they de facto offer and provide services for the purpose of which they need to use workforce? That's their phrasing. In my phrasing, that question amounts to, should platforms be treated as employers? And the second question is, should individuals doing low-paid episodic jobs in on-demand economy be considered employees or independent contractors? The authors are quick to answer those questions by yes, platforms should be defined as employers, and yes, platform workers should be defined or ought to be defined as employee status workers. The article then follows by justifying those answers, those yes and yes answers, by offering two kinds of reasoning. One is this legal and political trend that we're seeing all around the world, and in particular in the EU, to recognize platforms as employers and platform workers as employees or workers in other settings. And the other kind of justification is that a classification of workers as independent contractors bears some risks. Now, those risks include almost by definition, the exclusion of those workers from national workers protection legislation, national work law, and as a derivative, from the human rights framework of economic and social rights that national framework of work law should embody or actualizing. Then, after providing the substantive answer to their questions, the authors map two types of possible routes to enforce this substantive vision, that vision of platforms as employers and platform workers as employees. So there's two ways to actualize international human rights law in practice. There's the one that kind of subject the state to international human rights obligation in regard to those kind of economic rights that the platform companies are evading. And the other type of more innovative approach is to subject the platform themselves, platforms like Uber, under international human rights obligation. So just this kind of brief introduction, it's fairly clear that the article does a fair amount of work, and it does so in a pretty successful way. So there's a lot of kind of moving parts. What I read was the short version of the article. I think it's part of an ongoing work on the paper. I only got kind of the synopsis of the argument, so my comments now might seem kind of superfluous, or maybe it's something that you thought about and didn't have enough room to touch on, and so on and so forth. So as to my comments, what I really liked about the article is how clear it is on the substance. So the authors clearly think that platform workers should be defined as employee status workers, and they build their article around this premise as you define it. Again, I really like that you don't pretend that the question is kind of up for grabs and depends on the right interpretation of various legal instruments. Instead, you go the other way around and suggest that the right interpretation for what are the substantive obligations under international human rights and what are the kind of the subjects of international human rights law is the one that would work to actualize this goal of defining platform workers as employee status workers and platforms as employers. What I have to add on this kind of very clear vision is three small points that I think can strengthen the argument of the article. One is about the relations between the article and the specific technology, and the two other points I have are about whether or not international human rights does indeed solve some of the lingering problems of platform work. So the first argument, the first kind of question or puzzle that I have is with regard to the specific technology. Now it seems to me that your argument can apply to Uber as a platform company just as much as it can to any other kind of putative employer claiming that they are not actually employers and evade kind of work law. So the question that I have, especially in this kind of conference around platform work, a specific type of organization of work, is there anything special about technology in your story? Now I think that there's kind of four possible answers to this question. The first is that actually no, there's nothing special about platform employers. Tech here is just kind of a narrative that platform companies use to hide the theme, which is kind of violating workers' rights. So that's one kind of tech as a narrative answer. It has nothing substantive to it. The second kind of possibility is actually, yes, tech here does play a specific important role by aggravating traditional harms that labor regulations are supposed to remedy. They actually kind of makes the violation of substantive human rights kind of more severe. And that's something that I think if it's in there, then I missed it, or maybe it needs to be strengthened. Another possible answer is that, yes, again, tech does something to our legal argument, and it does something about who are the subjects of international human rights. So about your arguments that companies are to be subjected to international human rights, actually in the context of this particular technology, this makes our argument more correct or more urgent, not simply it will work as it will work on any other kind of employer, even non-tech facilitated employer, but actually the tech facilitated employer needs to be subjected more than the non-tech facilitated employer to international human rights. There might be other kind of stories in which tech, the particular tech of platform work involves in your argument, but I think that it needs some addressing. It can make your argument either more strong or more kind of concise, even broader. And the second kind of beef that I have with the international human rights frame is that suggesting this kind of as a framework, it seems that it doesn't solve all the issues or all the dilemmas that platform work begets. So the kind of the canonical problem is classification. How does implementing international human rights law solve the classification problem. Now, it is clear that employment law should apply on employees, but again, how do we define employees, or how does utilizing international human rights framework help us define employees in the way that we want? Now, again, there's two kind of possible ways that I can see articulated in the paper. One is that you can either claim that the jurisdiction that classified, for example, Uber as an employer got it right under international human rights, and the ones that didn't classify Uber as an employer didn't get it right. But finding out why they got it right specifically under international human rights law might be tricky. So, for example, why does control is a part of international human rights framework? Why does a correct interpretation of human rights law necessitates or does not necessitate the shifting of the burden of classification? And again, why? I think that there's another kind of radical, even more radical claim that can hide under this argument, that actually human rights law necessitate that all work, by definition, done everywhere by anyone, anywhere, is covered work, and that independent contractors, kind of a legal category, is under international human rights law, frankly, illegal. Now, I like both kind of possibilities of how international human rights law can help us do the classification struggle, but I need to see it more articulated in the paper. And my final comment is about international human rights law as a governance frame, perhaps similar to the comments Professor Kritzer-Levy got in her paper before, is that there are some benefits associated with international human rights law as a governance framework, but there's also some costs. So, for example, the loss of local or state sovereignty is one clear one, and it's important because it's not clear that in all contexts, under any circumstances, there's only advantages to classifying workers as employee status workers and not independent contractors. And then the question becomes, who gets to decide, who gets to govern this question? So my example, I studied the US. So in California, the California public kind of voted in significant majority to maintain platform work as an independent contractor work. Now, we can come into this frame and say, under international human rights law, you are prevented or preempted from making that conclusion. But again, at the loss of local sovereignty, local ability of politics to make its distributive choices about how it would like to allocate the rights and obligations that work provides in a particular community. So I think that there's some justification work that can be done for implementing international human rights kind of conditions all around. And some of them, I think, must involve a discussion of the costs of this framework. But overall, I really enjoyed reading your article. It's really stimulating. I learned a lot, and I look forward to the discussion.
Thank you, Gali, for your comment. And now, Izabela and Łukasz, the floor is yours.
Thank you very much. I have to admit, I think it would be good if we start from thanking the organizers for the opportunity to have this paper discussed today. We are actually at the initial stage of our research, so it is extremely valuable to get this opportunity in general and to receive all sorts of comment, feedback, and perhaps stimulus to improve the first draft. We admit it is only the first draft. We would like to also thank Gali for very insightful comments. I'm quite sure I will not be able to address them all. Probably I wasn't capable of even noting down all the nuances of your comments. So sorry for this. And I'm very glad Łukasz will be supporting me in that. So I think indeed, I would like to refer to one of the major starting points of our paper, which Gali mentioned, that is a certain misclassification that we emphasize in the situation that many actually workers, platform workers, are classified or are in a way presented as independent contractors. At least this is the narrative. We try to refer to this basic narrative of platform firms or platform employers, so to say. So this misclassification, and in this sense, we could say, what is, if we could in any way to somehow connect to the discussion that we had today, I would say, in Shelley's paper, issues such as informed decision, informed consent were mentioned. And I would say one of the problems of technology platforms is that they claim to offer and actually allure many young people with the promise of flexibility, of having their or being the masters of their time, how they organize their work. And de facto, people who engage may very frequently be disappointed with what is the result of it. That is, they realize that this promise is not being fulfilled. So the special story about platforms is that although they have the potential, and I think this conference has emphasized or is emphasizing both the potentials and the risks of platforms. So indeed, we try to sensitize perhaps or the reader as first element that it's not that there's a clear answer whether a platform is an employer or not, but a platform which is actually organizing the work under certain criteria. So for instance, if we have the subordination of the person who does platform work.
Not then AI, like social.
Okay, I think there was some, okay. So I could say there are, what is extremely helpful to refer to is the individual cases under states in many different countries, so under national law, and there is no answer whether Uber offers always employment or offers, for instance, actually the possibility of work for independent contractor. So there was a case in Australia where indeed the court decided that Uber is actually that the workers are not workers, but that the people who do platform work are actually independent contractors. Why? Because they do control their time. They can at the same time, for instance, work for other employers. So although in Europe, in France, for instance, or in Germany, there are cases where platforms were considered as employers or on the basis of the fact that the refusals to do work ended up in person being disconnected. So it amounted to unjustified dismissal. There are cases which are different. So I think just like Jose yesterday mentioned, very frequently we need to look at a problem contextually and not take a priori assumption that the reality is this or that. So we are fully aware that we are not capable of address all dilemmas. As we said, this was just initial paper. Perhaps I will still refer to, there's not much time, I think, because I think, Gali, you mentioned the issue, how do we justify somehow the role of human rights law as the governance framework which actually may infringe of the state sovereignty. I don't think we live in times where states are fully sovereign. So in the context of the EU, we can think in terms of pooled sovereignty. So no country is at present a sole individual island. And also the perspective of international human rights law is that of external support, we could say, to countries which freely, very frequently decide to be signatories of certain conventions. So it's like external, would that be support or control, if you wish? If we put it in terms of control, then we indeed may speak in terms of limited sovereignty. Łukasz, I think I should give you the floor, otherwise you will not have the opportunity to add on many aspects which I haven't commented on. Thank you.
Thank you very much, and thank you, Gali, for your comments. I tried to note them down, but I didn't manage to know them all. Nevertheless, your suggestion regarding specific technologies, so trying to show how that we could address different technologies, and that's true that we primarily based our paper so far on Uber cases, because that's the most prominent platform, I would say, at least in jurisprudence around the world. So that's actually something that we are still trying to deal with, to broaden the analysis, include other platforms, and see, or at least different sectors than Uber, because in all different contexts, the analysis could go in a bit different direction. So that's definitely something that we would like to work on. And if any of the participants is aware of any interesting pending cases regarding other platforms, that would be really interesting to hear. And another thing, actually, the suggestion on how to answer whether a platform is an employer and whether a gig worker is an employee or an independent contractor, I have to say that it's very daunting, I would say, for me to say that it doesn't matter from the perspective of international human rights law, because when you are reading recommendations of UN expert bodies, what can be seen from the analysis of historical recommendations is that they are constantly widening their scope, and they include different forms of employment, including even voluntary work, 0-hour contracts, and everything else. So I would say that this classification, whether we call, and that's why we also didn't want to spend too much space and time on discussing this, and we tried to answer in the very briefly in the introductory part. But I think that it would be maybe very interesting to try to distillate from the international human rights law the bare minimum of standards that would apply to both kind of works, and probably different scope for the employees and for the independent contractors. But nevertheless, I think that there is a bare minimum, so the minimum core content for both of them, and I think that's maybe defining that would be an interesting aim that would organize the whole paper. So thank you very much for sharing this thought.
Thank you, Izabela and Łukasz. Now we will open the discussion. So please raise your hand or write the chat, and I will let you ask or make a comment. Is there any question or comment? Shelly, please.
Yeah, I'll get the discussion started. Thank you, Izabela and Łukasz, and thank you, Gali, for this really interesting discussion. So I was wondering also, following Gali's notes, I was wondering if we are thinking about what we're interested and is protecting workers, do we really need to focus on the employee status, or can we think about other ways where we can protect workers? For example, I'm thinking about in France, they had they created a rule under corporate social responsibility, under this corporate social responsibility framework, where they offered certain types of workers, but also people hosts on Airbnb, not just people, not just drivers on Uber, just sort of a range of protections like vocational training and other protections that are not rooted in employee status at all, but rather they are focused on the platform's responsibility. And I was wondering if that could be a helpful framework for you as well.
Thank you, Shelley, for this very pertinent comment. I think we can quite clearly again answer yes, of course it is. It is from a very clear perspective. In France, in 2017, the law on the duty of vigilance was adopted. And part of it is that actually companies are no longer freely deciding whether they exercise or whether the activities are responsible or not. So corporate social responsibility as a concept is actually a voluntary concept. So we could say that France, as in Europe, is standing out regarding the very bold movement regarding introducing the law, which actually takes the concept of human rights due diligence, which is rooted in United Nations guiding principles on business and human rights, and making it a legal obligation. So for sure, it is relevant that and in this sense, we were also referring to private entities, businesses, here platforms, technology platforms, as being the duty bearers of human rights law. I think Łukasz emphasized this also, that from the perspective of international human rights law, we don't need an employee status. So what we need an employee status for is normally to grant or afford protection to platform workers from the perspective of national law. However, as Łukasz emphasized, international human rights law gives the opportunity to protect workers, especially in countries where such protection of human rights under national law is weak. So, of course, perhaps our paper is not explicit enough on that subject, but indeed we go towards the specifying, or even I would say advocating for platforms undertaking certain duties to respect human rights and safeguard certain basic rights of those who perform work. So that would be it from me. Perhaps Łukasz wants to add something. Thank you.
So maybe before handing over to Gali, I will just add that maybe we should start our paper actually from the clear statement that it doesn't matter. The whole discussion whether they are employees or independent contractors from the perspective of international human rights law, which we take actually in our articles. So maybe if we articulate it in this way, then it would be also, I mean, our message will be conveyed in much more clearly, I would say.
I'm sorry to intervene quickly. I just need to give Łukasz justice that he proposed it and I was not immediately convinced. Sorry for that.
Okay. Gali?
So thank you. The way that I would frame it is that we see around the world in national-based litigation that the entire discussion about regulating work is focused on a binary. It's either an employee status worker or an independent contractor. And I have some exceptions, Canada, the UK, where I have a third status, but this is I think that what your paper does, if articulated properly, is challenge this binary. And it challenged that in two ways. First is the possible radical argument, and it is radical, then under international human rights law, this binary doesn't make any sense. And we should strive to at least a minimum of social regulations under all kinds of classes or statuses. We're interested in protection, we're not interested in status. That's the one way where your article kind of holds the potential to challenge the binary. And the other place where your article challenged the binary is by suggesting that Uber, for example, can say, well, I'm protecting the human rights of my workers outside of the employee status. I grant them with certain minimum rights and obligations and perhaps duties that protects their human rights law, regardless of what the state demands that I do or not. I'm a good platform employer. Kind of you open up this kind of venue to circumvent the binary in another way. But I have to just say that this vision for how work is regulated is a radical vision. That is something that is kind of completely outside the way that we think and do regulations for work currently. And I think that this radical potential is really interesting.
Perhaps only a small comment, which will very briefly comment on Gali's statement that this international human rights law perspective is a radical perspective, and which also in a way will justify why I insisted on the binary, because it's so widespread in the discussion, as you said, or dominates. I think when we, without really questioning the radical argument, which we both with Łukasz support in our paper, we know that the reality is different. That is actually, if the protection under national law is weak, then it's extremely difficult to actually safeguard protection for employees or workers generally, because under this radical argument, any work should be subject to those minimal standards. So I think you excellently somehow summarized this point. Thank you for that.
Okay, any other questions or comments? Okay, Izabela and Łukasz, would you like to make some final comments?
I think from my side only really many thanks for this inspiring discussion. For sure, it's good food for thought to continue on the draft. So thank you very much.
Okay, I see that Gila would like to ask questions. Gila, please.
Yeah, so thank you very much. This is more of a question, out of ignorance, because I'm not very versed in international labor law. But isn't there a difference? So you're trying to activate the human rights perspective, but there's also at the same time the ILO perspective, which I guess would be less inclined to equating between employees and contract workers. So wouldn't there be some kind of a conflict between these two? So shouldn't you address that possible conflict?
Łukasz, would you like to comment on that, or shall I?
I could comment on that. So in general, I do agree that we should include more references to ILO, because actually the only way that the ILO works is somehow reflected in the paper is through the general comments of the UN committees, which always build upon the ILO recommendations and conventions, nevertheless, and affirm the all ILO framework. Nevertheless, we do not refer directly to specific ILO instruments, and that's definitely something that we should improve. So thank you very much for this comment.
Okay, thank you very much. Thank you for the authors and for the discussion. And now we will move on to the second paper, titled Crowdsourcing Compliance, the use of WikiRate to promote corporate sustainability. It is written by Galit Sarfaty from the University of British Columbia. The commentator is Tamar Barkay from Tel-Hai College. So Tamar, the floor is yours.
Thank you, Dov, and good evening all. Thank you very much, Tamar and Shelley, for the invitation to take part in this conference, and especially to comment on Galit's paper. I'm of course familiar with Galit's work and very much appreciate it. So it is indeed great honor for me. I'll begin with presenting the main issues discussed in Galit's paper titled Crowdsourcing Compliance, the use of WikiRate to promote corporate supply chain transparency, and will then offer actually a very few comments. At the heart of the paper lies the question of whether crowdsourcing is a good or efficient or trustworthy mechanism for assessing corporate compliance with supply chain disclosure laws, and ultimately for encouraging sustainable performance among corporations. The shift in recent decades to more hybrid mechanisms of governance, what is often termed regulatory governance, has turned the challenge of compliance into a major issue. Supply chain disclosure laws are a case in point. Such laws are relatively recent development within what I see, now it's me, not Galit, what I see as the pendulum-like movement of the struggle over the governance of global supply chains. While the global widespread of private codes of conduct since the 90s marks a movement of decentering the state, the emergence of supply chain disclosure laws, which is at the heart of this paper, in recent years heralds a counter movement of recentering the state. These laws attempt to tackle human rights violations and severe forms of labor exploitation by requiring corporations to provide information on their supply chains and on the measures they take to prevent such violations. In other words, the idea of such laws is to increase transparency and to expose corporations to consumer and public pressures. However, as Galit say, and I agree, they don't seem to work so well, in part due to low compliance rates. So based on this understanding, the paper seeks to explore, and I quote, the actual benefits and challenges of using crowdsourcing to assess, measure, and incentivize compliance with supply chains disclosure laws. The importance of this research project, as I see it, lies also in the fact that while crowdsourcing has been used in early stages of regulatory governance, such as agenda setting, reviewing existing legislation and shaping new policies, it is rarely used for assessing and measuring implementation and compliance. And I will add that implementation and compliance are a real problem with such laws. So for this purpose, the paper focuses on the case of WikiRate. Founded in 2013, WikiRate is a crowdsourcing platform that is used for tracking and monitoring corporate performance. So within this framework, it operates, among other projects, 2 projects that focus on corporate compliance with respect to 2 specific supply chain disclosure laws, the UK Modern Slavery Act and the US Conflict Minerals legislation. I will not go into detail with these laws. I'll just say that the former, the UK Modern Slavery Act from 2015 requires any organization that conducts business in the UK with a certain annual net turnover to publish each year a modern slavery and human trafficking statement, which should be approved by the organization's board of directors and signed by a director. The latter, the US conflict minerals legislation, requires publicly traded companies that manufacture products using certain conflict minerals to provide a form special disclosure to the US Securities and Exchange Commission on whether the sourcing of the minerals originated in the Democratic Republic of Congo and bordering countries. And if they do, they must submit also a conflict minerals report describing the due diligence measures taken to assess whether those conflict minerals directly or indirectly financed or benefited armed groups in the covered countries. Both laws suffer from low level of compliance and poor quality of disclosures. And this is reported for several years now. So for assessing compliance with the UK MSA, WikiRate has designed metrics which were used by over 1,000 students as well as other citizens who participated in the project. In all, 1,200 modern slavery statements were assessed. However, WikiRate has employed experts to perform an additional level of verification of the data produced by citizens and students. So in other words, WikiRate did employ citizens and students, or managed to engage students and citizens, but didn't trust them actually, and employed experts to verify the data. From the data, WikiRate published 4 reports, actually quite impressive reports with recommendations on quality of statements and good business practices regarding these legislations. The assessment of statements that companies produce under the US conflict mineral legislation was conducted by volunteers from Cambridge University and Amnesty's network. They too were given metrics according to which they performed the assessment. However, this project, according to WikiRate itself, has not been successful as they think the UK MSA project was, largely because there was a wide variety of statements which made it difficult to non-experts to compare them according to a standardized methodology. So basically, we have 2 projects with different level of success, but in both cases we have WikiRate had to use experts or realize that without experts it cannot be done. Given the challenges both projects faced, including engaging the public, recruiting informed volunteers, need of expert verification of data, standardization of assessment, etc. The Galit suggests that for the mission of assessing such complex disclosure, non-expert-based crowdsourcing may not be the most suitable tool. So basically, I think this is the main conclusion of this paper. And then she adds a kind of an idea at the end, which she does not develop, but suggests that maybe for assessing legal compliance, expert sourcing would be a better tool. So this is the main issues in the paper, and I turn now to my, I say 2.5 comments. First, I'm interested to hear more about the idea of expert sourcing, especially because I'm familiar, Galit, with your really wonderful paper on SEDEX, titled Translating Modern Slavery into Management Practice, in which you develop the idea of the chain of translation. So I fully agree with you that in translating unstructured data on human rights violation and labor exploitation to quantitative indicators, experts play a major role in regulatory governance. So I'm not sure if you refer in this paper to the same kind of expertise, and if not, what are the differences between the expertise that you discuss in the other paper and the expertise you suggest here or refer to here. So this is the first comment. The half comment is that with this analysis in mind, your analysis of the chain of translation, and also thinking of the worker-driven social responsibility as developed by the FFP, the Fair Food Program, I think that maybe stakeholder sourcing, especially workers and unions, rather than expert sourcing, is a more suitable tool. And I wonder what you think of this idea. And lastly, my second comment, second and a half, I think that it might be the case that the problem is not the nature of the crowd, but the nature of the legislation. As you suggest, supply chain laws such as the UK MSA have, I'm quoting, have been widely criticized for only mandating disclosure of corporate efforts to conduct supply chain due diligence and imposing very few, if any, penalties for non-compliance. So in other ways, I'm not that sure that the problematics of disclosure laws lies in the low compliance rates, or maybe if compliance rates were higher, I'm not sure we would be in a better situation regarding human rights violations. Thank you.
Thank you, Tamar. Now, Galit, you can respond.
Great, thank you. I first want to also thank the organizers, Shelley and Tamar, for inviting me here to this excellent conference and inviting me to join this exciting dialogue about crowdsourcing. And of course, to thank Tamar, whose work I'm also very familiar with and very much admire in this area, to comment on my paper, which is very much a work in progress. And I look forward to any other comments that others have as well. Tamar, thank you so much for summarizing the paper and for your excellent 2.5 comments on, I think it's more like 3 comments, I think, certainly, on the paper. I'll take them in order. I think they're all wonderful points. I had to think much more about, so I'll give you my initial reactions, and I've written them all down, and I think they're very, very useful as I return to the draft. The first point about expert sourcing, which I end the paper with, and I see your question is asking which experts. Am I talking about the experts that I wrote about in the paper that Tamar mentioned on SEDEX? SEDEX is a platform that helps businesses with supply chain due diligence by developing indicators, and SEDEX is mostly made up of management professionals, not legal, not lawyers or others. So a certain type of expert. And that is a question that I haven't put enough thought into. My initial reaction would be that because these laws, the UK Modern Slavery Act and the US Conflict Minerals legislation, which is Section 1502 of the US Dodd-Frank Act, these laws were meant to have consumers and the public as the audience, particularly the UK Modern Slavery Act. The US legislation is a securities law, so it's a little bit more complicated who the audience is. But the UK Modern Slavery Act is the more successful project of WikiRate, and it's also the law that has served as a model for other legislation. In Australia, they have a Modern Slavery Act. It was modeled after the California Transparency and Supply Chains Act. So consumers were the primary audience. So when I think about expert sourcing, I immediately think, well, it shouldn't be management professionals like those that make up SEDEX. It shouldn't be even legal professionals. Ideally, the crowd that is supposed to be reading these disclosures are supposed to be regular citizens. When I interviewed the managing director of WikiRate about the two projects, and particularly why the conflict minerals project failed, and she mentioned that certain students were a good fit for this kind of project, law students or other students or citizens who are more familiar with reading types of disclosures, are more familiar with the contentious language that companies use in these disclosures, the double negatives, the fluffy language, and being able to read through it. So I don't think that one needs to be an expert with so much specialized knowledge, but one has to have a familiarity with reading these disclosures, being able to interpret them. And if not, I think the problem becomes more about the metrics and more about the guidance. I wrote a paper a few years ago on the limitations of supply chain disclosure regimes that was based on an experimental study on the disclosures that were produced by the California Transparency and Supply Chains Act. And my co-author and I, Adam Chilton, found that in that case, it would have been more useful to have very simplified disclosures that consumers would more likely read, maybe a template of just a few categories that would make it more readable, make it more decipherable, make it easier to compare across companies. And I think that's what's missing now. In the UK Modern Slavery Act, the UK government has gone further in trying to provide more guidance as compared to other countries. And I think that observers are waiting for it to go even further based on a lot of the critiques of these laws and of that law in particular. They need to provide not just more guidance, but just a simplified version of the kind of information, because you end up having the size, the length of the disclosures being a proxy for the quality of due diligence, which is not necessarily the case. This gets actually to the last comment I think that Tamar mentioned, and I'll go back to the second comment. Her comment was, is this really a problem about the nature of the crowd, or is it more a problem of the nature of the legislation? And I completely agree that as other scholars and policymakers have argued, these laws are not doing enough. And perhaps they're diverting attention from other potential laws that can do more to improve performance. I note what Tamar mentioned at the beginning of her comments, this shift, there was a decentering of the state, and then now a movement towards mandatory regulation, but disclosure regulation, which all of us who know what disclosure regulation is, we know that there's a lot of limitations to disclosure laws in all areas, not just supply chain disclosure laws. But I always see it as a first step. I come from an international law background, worked in transnational business and human rights, what the last paper was about. And in this area, everything was soft law for so many years, codes of conduct, voluntary norms. And then in 2010, you started having this development of mandatory laws. But yes, mandatory disclosure laws, which certainly have their limitations. And I agree that is the central problem, not the crowd. But I do think that's what we have now, and that's the first step. And ideally, we'd at least improve the quality of the statements that are going out. I think that even though consumers were the initial audience for these disclosures, they are now being used by a lot of other stakeholders increasingly, by investors who are reading them, by NGOs, by governments themselves. So they are a source of information that's out there that's required. So I think that attention should be placed on them, on trying to improve their quality through this kind of crowdsourcing compliance potentially, while at the same time trying to work towards more effective type of laws. And now getting to the second point that Tamar raised about stakeholder sourcing. I think this is related to the first point about expert sourcing. And I think that's a really good point. I have to think about that more, about whether the disclosures would have to be designed in a different way for different types of stakeholders to be able to interpret them. I think that certain stakeholders would have the capability to do so more, and would certainly have more of an interest in reading them and caring about them and putting pressure on companies, ideally. And yes, I think I'd like to certainly expand upon that section about who that crowd should be. So thank you very much, Tamar, for your excellent comments.
Thank you, Galit. And now we will open the discussion. So please raise your hand. I will let you ask a question. Sharon.
Thanks. Galit, I really enjoyed your paper. So thank you for that. It was very interesting to hear about this crowdsourced project. So I got the sense from your draft paper that you point to two types of regulatory governance failures, and just to continue the discussion you just had, I was wondering if you have any initial ideas about perhaps suggesting a different type of regulatory governance mechanism, since I think you point to the fact that the disclosure regulation tool did not work, and the crowdsource mechanism mostly failed. And so these are major issues of human rights, mineral conflict minerals, and the modern slavery. So the reader is, at least I can say for myself, is left perhaps discouraged and wonders what will the future bring for these issues in terms of law and regulation.
Thank you, Sharon. Yes, I think that you're pointing, and Tamar as well, to this tension that I have as well about, do I just completely reject these laws and say this is a bad idea, or do we try to work with them? And I think my last comments were saying I'm trying to work with them, work with the information that's there. That's what we have. It takes a long time to pass laws. Countries like the US usually don't pass laws in this area, but we are seeing great developments in Europe in particular. I think that I probably favor both, working with what we have and thinking about other more creative regulatory governance mechanisms. That you ask about what else is out there. I think the last paper, we had a brief mention of the French duty of vigilance law. There's non-disclosure laws in Europe regarding human rights due diligence requirements and real penalties that are being placed on it. I can't say that I'm an expert in these areas of those particular laws. I've read what others have written about, but I think it's too early to tell how effective they will be. But even WikiRate itself, when I interviewed them, they said now they're excited and looking to see what these human rights due diligence statements that will be coming out, what these disclosures will be coming out will look like. They go a lot further than I think the supply chain disclosures, but do they go far enough? I'm not sure. I'm in Canada, and Canada hasn't passed laws in these areas, not even disclosure laws. But there's been really interesting developments judicially, trying to achieve corporate accountability through tort law. We have a case, Nevson versus Araya, that just went to the Supreme Court a couple of years ago, that made a great step in holding a mining company accountable. And I think a lot of countries are watching that. So I think it's too early to tell, which mechanism has the most potential. I think it's very fruitful to go in different directions and kind of see what will make a difference. And perhaps it'll make a bigger difference in some countries than others, or there'll be different regulatory mechanisms that will make a difference in some countries where it's more difficult to pass laws, but maybe easier to use the judicial system to reach accountability. Thank you.
Tamar?
So thanks, Galit. I really enjoyed the paper. I want to ask a question about the particular mechanism in which this data is sourced from the public. And my concern is, in the background, is that we've seen in Israel, and I'm sure it's the case elsewhere as well, we've seen commercial companies buy positive reviews online and buy likes and shares and tweets and et cetera on Instagram. So we've seen this manipulation of platforms with bot armies and avatars, et cetera, that I'm worried will sort of infiltrate into this mechanism as well. And so, and will create this capture or this bias or manipulation of the process as well. So can you say anything, or if not at this stage, maybe this is something to consider about the mechanics of how this data is sourced from the crowd, whatever that may be? Is this anonymous? Are people required to identify themselves? Is there any way to prevent this manipulation or address it in any way?
Yeah, thank you. I think Tamar, you raised an important challenge that WikiRate itself, I think, has identified as well, the potential manipulation of the data, and the difficulty of also getting and recruiting a broad representation of users who would be able to look critically at these corporate statements, not just understand them, but look critically at them, or maybe not too critically, but kind of have a more balanced point of view. So to answer your question, they do try to address that by requiring peer review of any data that's posted. So there's the initial review, initial assessment by one user that has to then be reviewed by another user. The users are identified. What I found interesting is that WikiRate allows for the distinguishment or the differentiation between different categories of users. So some users are maybe given varying levels of credibility. So for instance, you can see if the user is a student at Cambridge University, as was the case for a lot of the users for the Conflict Minerals Project and other students, or the user is an employee at WikiRate who's doing an expert verification, as Tamar was talking about. And so that does allow one who's reading these assessments to distinguish. And clearly WikiRate found that wasn't enough, that then they went further and did this expert verification to ensure that there was an accuracy of the data. All of the data does have to be referred to a public source, and so they make that reference. It's almost like Wikipedia, right? You see the whole edit history and you have a reference to public sources, but as we know, even that can be manipulated, right? So so there are issues there, and I think WikiRate is struggling with a lot of those, and we're seeing that in practice. Thanks.
Mm-hmm. Thank you. Gali?
I have a technical question. Is there something in this crowdsourcing endeavor that a strong natural language processing algorithm can't replace? Is there some unique role for the crowd in kind of sifting through all of those data points that we can't kind of produce a technological tool that would replace it?
That's a really interesting question. WikiRate just produced a report about artificial intelligence and the potential of using that. And I know they're working on that. And I think a lot of it depends on the legislation at the same time, right? Because it depends on what information is in these disclosures, what's required by the laws. I don't have that much confidence that it would be that effective if students who have as an assignment for their course have difficulty assessing these statements because of double negatives, because of fluffy language. I mean, even when I sit down and read them, it's not so easy to figure out whether a long disclosure by a company that talks about respect for human rights and supply chain auditing, to read it and be able to figure out, well, wait a minute, this may not be an example of a high level of due diligence. There aren't, for instance, unannounced audits. How often are the audits? You know, you have to know about what to look for. And I don't know enough about artificial intelligence. It's not my area, but it seems to be a hard thing to use AI for this situation, unless the information that's required in these disclosures is so oversimplified, which may be useful. And I'm not sure where's the balance. You get too oversimplified, then is the disclosure going to mean anything? So it's a tough call, I think. Great question.
Any other questions or comments? Gila, please.
So thanks. This is really interesting, and I'm a bit confused because I'm trying to understand the role of crowdsourcing in all of this. So what is the difference that you define between this and, you know, any other, you know, efforts before technology or whatever, just to use students, to use you know, to use volunteers to check compliance, check. So where do we? What's the innovation here? You know, as opposed to the first paper that we discussed with the environmental, you know, with the environmental cases in which we actually you see the people who are affected by it actually participating in enforcing it. Here you're, at least to the best of my understanding, you're simply describing a process in which many people are concerned about something, and so they're trying to check it out, just like they did, you know, 50 years ago, for that matter. So I would like to really to understand better what the you know, what the uniqueness of this situation is with respect to crowdsourcing, as far as you're concerned.
Sure. Yeah, that's a great question. So I think the situation with these laws is that NGOs had created registries of these disclosure statements. I mean, there's thousands of these disclosure statements that since 2010, 2015, in the case of the UK Modern Slavery Act, have been posted on the websites of companies. And there's a question of anyone's reading them and anyone's assessing them. You had some assessments being done by some NGOs, Business and Human Rights Resource Center, some academics have done some studies on a subselection of these statements, but there was a whole trove of information out there of all these statements that are produced annually and they're required to be produced annually by companies. And who was reading them, who was assessing them. So I think that WikiRate's goal was to create a data, not just a database of information, but to encourage peer production so that you would use the crowds, use citizens, mostly students, to actually read these and assess them. The Conflict Minerals Project in particular was developed in consultation and in partnership with Amnesty International. Amnesty International is an NGO that had been studying them and found that they just did not have enough resources. They didn't have enough man-woman power to read these statements that continuously come out every year. So that was the impetus behind that project. And you have more and more universities partnering, so more and more students looking at the statements. There's still not enough. I think Tamar mentioned in my paper, I talk about 1,000 students that had been involved, but there's about 10,000 statements in some cases. So what WikiRate is now doing is making kind of well, I should say projects that are focused on sectors. They did a project just on the hotel sector. So there's a smaller number of companies that need to be assessed. So I do think that it is innovative in that in the case of disclosure laws, assessing compliance is assessing these disclosures that are being issued every year. And it's using the crowds to read them, to give them the metrics. I mean, what's useful about WikiRate is they don't just list the metrics. They have really useful kind of tutorials. They for each metric, they have examples of the kind of language that you should look for, examples from other statements. They allow users to ask questions to experts from WikiRate on, well, I'm not sure about this particular statement. Does it comply with the metric? Is there due diligence being done here in a particular way? And so they are providing those tools based on their own expertise to allow users to read them. But again, the numbers don't really translate quite yet. There aren't enough users to read all the statements. I hope that answers your question, Gila. Thank you.
Tamar?
Hi, thank you. It's super interesting. I never heard about it before, and I have a lot of questions from curiosity. But following the last comments and Gali comments, I'm wondering whether we can look on the diversity of the contributors, experts, non-expert, as a feature and not as a bug. Because if I'm imagining like machine learning doing this job, then I can see how very fast the companies themselves could find a way to gamifying with this system and to find the way to get good review without really doing the real job. And I think maybe there is a good feature in this, that there's a lot of a perspective of the contributors, a lot of background and a lot of understanding of language, because with machine learning, the uniformity is becoming very fast, like they have like one standpoint, while in today we have like diverse opinions.
Yes, I agree. Thank you. Yeah, I agree that machine learning, the use of AI can be more easily manipulated, is what I hear you saying than this type of model. I think that's a great point. I see that as a comment, and I completely agree. But we still have to think about again recruiting users that are broadly representative, and there's still manipulation that's possible. A different kind of manipulation, and maybe a lower level of manipulation. But thank you. That's a great point.
And just I have another question from curiosity. There's some like equivalent project that really checking the content of the disclosure, whether it's right or wrong, or like giving the people that may be affected by those companies to really, or the workers or whatever, to really say what they think about the content of the disclosure.
If I hear you saying of verifying if what the companies are saying is right, like if they say we do this many audits, no, that is not going to be possible. And that's a problem. I mean, sometimes what you do have, this is why it's, I think, useful to have the information out there. You've had some lawsuits in the US, for instance, of against, for instance, chocolate companies that have been accused of child labor in Cote d'Ivoire, of saying your disclosure says you did this supply chain due diligence. In fact, our investigations say that you did not, and that there was child labor and you did not disclose that, and you knew about it, and we have that evidence. That's very rare, as you can imagine, right? But having that statement out there is useful for that. Otherwise, it's so hard to go in and verify that what they're saying is true. So you do have that problem. But once the information is out there, if one is able to verify that what they're saying is false, sometimes that can be the source of litigation for false and misleading statements by the company.
Izabela?
Yes, thank you. A small question regarding the quality of disclosures and the possibility of perhaps having a kind of standardized answers that should be provided by the companies, because it seems to me that at least at the beginning of the discussion, or what makes for NGOs or general public difficult to read those disclosures is very frequently lack of standardized elements that must be disclosed. So even though perhaps I wasn't following the latest developments in that field, but it seems that that was part of the problem regarding the assessment of the quality of such statements. And then my question would be, if that's really a problem, would that help to improve perhaps the tools such as WikiRate, if indeed this standardized reports or disclosure mechanisms would be introduced? Because there are some recommendations, but we know if companies are not even sanctioned for not having published one, so they are very frequently skipping certain elements which are recommended to be disclosed. Perhaps you could comment briefly on that. Thank you.
Thank you, Izabela. Yes, I think it would. I mean, your question was if there were standardized disclosures, would that help improve WikiRate and what it's doing in its goals? I think it would. I think it goes back to some of the earlier questions about you get too standardized, or at least too simplified in the kind of information that you're asking, that then would companies be able to manipulate that, or would you really be able to assess differences between the companies? I mean, you have to really identify what is the most important information and in what format should it be given. So I think that's still going to be the challenge moving forward in thinking about that. I was quite surprised when I first found out that the Conflict Minerals project had been canceled by WikiRate. I had spent time, in the past when the Dodd-Frank Section 1502 came out and reading the disclosures, and some of them, when you have very clear metrics, they seem easy to read, but then I realized, well, maybe it's because I've been reading them and I'm more familiar with these terms. And they found that it was very difficult to assess. So I think that I think you're right that there's a difference between recommendations that are provided by governments and the requirements. In the case of the 1502 statements, there are recommendations on the statements, as you probably well know, like the recommendation to use the OECD due diligence guidance for supply chains, but a lot of companies aren't following them. And the same for the UK Modern Slavery Act with their recommendations. So I do think it's going to have to be a requirement to make sure that you can compare companies across the board on these issues. Thanks for your comment.
Łukasz, please.
Thank you very much. It's a really interesting topic, and I just Googled WikiRate and joined the WikiRate just to go through it. It looks really interesting, and I think that following up on what Gali asked about AI and AI-driven recognition of different patterns and terms, I think that both approaches can be merged in a way that the first introductory research, let's say, is done by AI, and then the crowd or the researchers are deployed on the much narrower material, so selected provisions, those that are fuzzy, etc., etc. And in this way, also you can control on the performance of the algorithm, gradually make it better and better, and also you can cover much more because you have this persons focusing only on something that is probably much more relevant than anything else. So I think both approaches could be merged, and it would be actually, the benefits are scaling up very, very. I would say the scale increases very, very fast. So to say, thank you.
Yeah, thank you. I think that's a great point, and I really appreciate the comments that others have made about the use of AI. Something I haven't given enough thought to, and I need to read much more about it. And I think you're right that there's WikiRate is currently used for metrics such as, has the company posted this disclosure on its website? That's something that a computer can easily go and check. So you're right. There's a lot of questions that users' time is being used on that can be easily deciphered through machine learning. But then the more difficult questions about that really require humans to assess, maybe the time of users should be spent on those. So that's very helpful. Thank you.
Shelley?
I thank you. This was really interesting. I very much enjoyed the paper, and I have more of a comment about the discussion, the general discussion of what can a crowd do in the context of compliance. So it seems to me from the discussion and from reading the papers that crowds can gather information, right? And we saw that in Anna and Amelia's paper yesterday. I think we'll say tomorrow in Sharon's paper. And that's one thing. And then the other thing that crowds can sort of process and interpret information. And that is something that your paper sort of points out that this is something that's very hard to do, and we need experts to do that. And then I think that there's another function for the crowd that also comes up in your paper, and that is the actual sanction, right? So the whole idea of disclosure relies in a sense that consumers will then, the crowd of consumers will then apply some sort of consumer pressure that will have some sort of an effect. So just a general comment.
Great, thank you, Shelley.
Okay, any other questions or comments? Okay, so thank you, Galit and Tamar, and all of you for a very interesting discussion. And please join me in thanking the organizers, Shelley and Tamar, for another wonderful day in this event. And we all look forward for the discussions tomorrow. Thank you.
Thank you, Dubi. Thank you, everyone. See you tomorrow.
Thank you all for such a great discussion, and to the presenters and commentators and chairs and everybody that contributes. Thank you.
Thank you. Goodbye.
Thank you. Good night.
Good night.